record on my computer, and away we go. Welcome, welcome, everybody. This is, of course, She's the Boss's online learning table. And our star for today is Binh Rai. And she's amazing. She's absolutely amazing. I was talking to her the other day, and she's a trademark attorney and is the founder of Seriously Trademarks, which is a trademark filing and registration consultancy firm. She specializes in advising you whether your brand is trademarkable or not. And Binh has filed over 1,200 trademarks. I'm sure that's gone up since you've probably written this, and has over 10 years experience helping on companies to resolve trademark matters, whether to do with infringement or starting a new brand. Binh is also known in the industry for her brand marketing and trademark knowledge, and helps clients understand how their brand is structured and how they can use it in the marketplace. And in the few moments that I spoke to Binh, we figured out that my trademark had expired and that I was I needed to address mine. So yes, it is definitely worth listening to Binh's conversation or her presentation today to find out more. Over to you, Binh.
Thank you very much, Antonia. Thank you, everyone, for making the time. I know everyone's time is precious. My name is Binh Rai. I'm the founder of Seriously Trademarks, and I've been a trademark attorney, helping business owners basically ensure that they are not infringing on somebody else's brand, but also educating you on what is trademarks and what is intellectual property protection. So with that, I will share my screen and we can get started.
And of course, everybody, put your questions in the chat,
Yes.
and we will address them as we go along.
And yes, I'm more than happy to, as things come up, I'm more than happy for you to interrupt and ask questions as we go, because I'll be running through a few case studies. So let's go there. So a disclaimer, just quickly, this presentation does not constitute any advice. It's just general information that I'm sharing, and feel free to contact me afterwards if you've got any other questions. So what I'm hoping today is to basically, tell you, well, for you to find out why trademark protection is important for your businesses. Learn about the various different types of trademark protections that are available to be registered. I'll demonstrate these by going through case studies, just so you know when and where you need to look out for trademark protection. And I'll also go through some other intellectual property considerations, because there's a lot of confusion out there about various intellectual protection, just like trademark, copyright, and we often get clients thinking it's the same thing, but it's actually very different. So let's start. Okay, so imagine why is it that you need a trademark? Imagine that these brands, Apple, Amazon, Google, imagine they didn't actually trademark their brand at the start. Today, Apple's worth $263 billion. Their brand's worth that much. Amazon, $254 billion. And Google is valued at $191 billion. So with these companies, you've got to remember that they all started small as well. So Apple, I believe Steve Jobs started in his garage. So these companies all started small as well. But as they became bigger, or they grew, intellectual property protection, especially trademarks, was very important to them, because what they want to do is make sure that no one can use their brand as they grew, and also to tarnish their reputation if someone is using their brand. So, these figures for 2021, I'm sure they're more valuable today. So what is a trademark? Okay, a trademark is a sign. It includes a word, a logo, a slogan that differentiates your products or services from those of other businesses. So it's to basically identify you for your brand and to protect you for your brand. The trademark gives you the legal rights to use the brand name. At the moment, many people, I find, think that their brand is protected because they've got a company name, and that's actually not true. So a trademark allows the trademark owner to continuously use their brand in the marketplace without fear of trademark disputes and infringement in the future years. A valuable asset that can be sold, assigned, or licensed to other companies. These are the various types of trademarks. You can trademark letters, as you can see, the Boston Bee baseball team. Numbers, 99.9 is owned by the Bradman Foundation. You can trademark a word. So McDonald's and McCafes are owned by McDonald's. And also a logo. The M, the McDonald's M has been trademarked. And you can also trademark a phrase, "Just Do It" by Nike. Imagine if Nike didn't actually trademark "Just Do It." Their competitors can use that phrase. One thing that I want to make clear to everyone is that a logo mark is different to a word mark. We always advise that the small business owners or any business to trademark the word, because the word gives you the exclusive rights to those words, where a logo mark only gives you partial protection for the brand. But the logo mark is more protection, a combination of the look and feel, and gives you partial protection for the actual words itself. So the word mark is the most powerful trademark protection you can obtain. You can trademark packaging. So we've seen those. Happy Meals, Coca-Cola bottle. You can even trademark a scent. Very rare, but it's possible. So the scent trademark I found on the trademark register was a company that has a scent mark for eucalyptus scent for goods for golf tees. So go figure that. It must be very special for them to trademark it as a scent. The shape mark. We've seen this in the supermarket. So Toblerone, their chocolate shape is very unique, and that's been trademarked. And it, as marketers, or as even business owners, we know that anything that can give us an advantage is important to protect. So in this case, by Toblerone is owned by Kraft Foods. They have trademarked the shape of their chocolate. You can trademark colors. So the bananas in the supermarkets, the tips of those bananas, they've been trademarked. The yellow and black in the financial services area is owned by Commonwealth Bank. Orange, green, and red owned by 7-Eleven in that combination. And also the most famous purple, Cadbury's purple, they successfully had trademarked that around the world. And that was a very critical trademark for them, because when Darrell Lea wanted to introduce a range of chocolate packaging in purple, Cadbury actually took them to court, and I believe they won, and therefore Darrell Lea couldn't use that purple in their packaging for their chocolates. And you can also trademark what they call a movement mark. And it's basically like a video sequence where it's played on the internet again and again as something that finishes, let's say, a news report, or like the BBC. They've got this movement mark where the sequence of those images they've trademarked. You can trademark a sound mark. So fingers crossed this is going to work. Okay, it's not working. What you can do is I might copy and paste that later. So basically 21st Century Fox, when you go to the movies, and I think either at the beginning or at the end, it's like dun 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 dun. They've actually trademarked that sound mark, and it's unique to them as well. So
nice bit of voiceover there, Ben.
Sorry.
Nice bit of voice over there.
I don't know. That was just in my head. It may not be the right tone of the
At least you
music,
didn't
but
have to
you
do
know
the
what I
lion
mean.
roar.
Yes, that's right. The line roar as well. Uh, there are actually various types of trademarks within trademarks as well. So the ones that we know are the standard trademarks, the ones that I've just shown you. Okay. There are actually the standard trademark is used to distinguish one trader's goods or services from those of others. Okay, so that's the standard one. And then we've also now have certification marks. A certification trademark gives um, third parties permission to use the mark as long as they follow a set of rules. Okay, so with a certification mark, the owner of the trademark doesn't have to prove use of the trademark. They can actually license out that trademark for others to use. And I'll go through that a bit later with examples so it's a bit more clearer. So as I said, the certification mark is used to authorize users to guarantee that goods or services possess particular standard. So I think the Australian made mark is a certification mark. Uh, it basically the owner of that trademark cannot give it to anybody. They actually have to meet a set of rules before that trademark is being able to be assigned to somebody else to use it. So I believe with the Australian grown certification mark, about 1,700 companies have been licensed to use it, with over 10,000 products sold globally. So that's been a very successful certification mark. And then there's a third type of trademark. It's not as popular, but it's a collective mark. And a collective mark is owned by associations. So no one actually owns that trademark. Everyone within that association, when you join them as a member, everyone owns that trademark. So that's what we call collective mark. And as I said, it's usually owned by, trade associations or industry associations where the members own the trademark. So trademark ownership is really important when you're applying for a trademark. And this is where a lot of people that self-file get this wrong. So if you actually file the trademark in the wrong ownership at the start, that trademark is actually invalid, even though you may have paid the government fees and you've gone all the way for it to be registered. However, if you actually had applied for in the wrong entity in the first place, that trademark can be challenged and be invalidated later on. Okay. So the various trademark owners can be an individual. So for example, if you're a sole trader, then you would apply for the trademark as an individual because you can't apply for it as a sole trader. It's in your personal name essentially. You can apply for it as a company. So if your business is run through a company, then the company needs to own the trademark. And this is where at times I see this happen a lot, where people who own companies believe that they're the owner of that company. So therefore, they're the ones that are the rightful owner of that trademark. That's actually not the case. Just because you're a director of that company, you actually shouldn't own the trademark because it's actually the company that's using the brand and it should be that company that owns the trademark. So again, as I say, I'm just trying to be very careful to make sure that you understand that you need to know who is using the trademark at the time that you apply for it and apply for it in the right entity. An incorporated association can own a trademark. And more than you can have more than one multiple owner if you've got partnerships. That can get complicated. So I would advise that you seek advice if you've got like a partnership agreement where there's no company, but it's a partnership. So as I said, importantly, the trademark owner must be the rightful owner of the trademark at the very start. If the entity that owns the trademark registration does not use the trademark in the course of trade, that trademark can be challenged and invalidated in the future. And especially if you're looking to franchise in the future and you've got big dreams to grow your business and you want to franchise it, it's really, really important that you get the trademark and the right name in the first place. So the applicant must have an address for service in Australia and New Zealand. You could, some companies overseas may use an accountant they've got in Australia as their service agent or their trademark agent's address. It can't be a business name or a trading name. So that's really important. There's a lot of companies, like for example, my company, I'm Umbrella Projects Proprietary Limited, but I'm trading as Seriously Trademarks. So when I apply for the trademark, it's Umbrella Projects that owns the trademark, not my trading name. So my trading name is Seriously Trademarks. So the should be so the trademark needs to be owned by the owners of the business company name. Should be the corporation's name if it's owned by the corporation, and not in the name of the directors, as I stated before. And if you have a company that, if you've got a trust can actually not own a trademark. It's the trustee that operates that trust should be the owner of the trademark. And again, that can get complicated because sometimes a trust can be run by, the trustee could be an individual and the trustee could be a company. So again, just be careful if you are wanting to own the trademark and you've got a trust running the business. So through the 12 years that I've been operating, this is the biggest thing that I always come across. A lot of new clients will say to me, I don't need a trademark. My company name gives me protection for my business. And that is actually false. Your company name does not give you the right to that brand name that you want to use in the marketplace. And the company name, a trading name, a domain name, trading history, they do not provide you any legal protection for your brand if there's going to be a dispute between you and another party. So, as I said, many believe that, once you register a company, that you own it. But I'm just going to give you this example where I had a client. It was Australian United Developments Proprietary Limited, and the other party was Australia United Development Proprietary Limited. So this example clearly can show you that ASIC does not always get it right when they issue out company names. Because if you looked at those two brands in the marketplace, you potentially, as a consumer, would accidentally think that they've got some relationship to each other, or even at a glance, think that they might be the same company, because I've just easily highlighted to you in red the differences. But if you were a consumer and you just looked at it, you may have thought that they were the same company, okay? And they both operated in the building industry as well. So these two companies operate in the same industry as well. And ironically, what had happened was my client wanted a trademark, and they had been operating for 5 or 6 years, and it just happened that they both wanted a trademark around the same time. And so anyway, we resolved it. We ended up getting our client their trademark as well. And in that case where someone has applied for a trademark prior to you, there are actually avenues of negotiation with the other party to ensure that both parties can own the trademark. Okay, so this example is more just to show you that ASIC can issue similar company names. So surely ASIC would not allow another business to have a similar name. Well, I've just given you another example, ACE, ACE Construction. How many ACE Constructions or building companies are out there? There's many of them. So the problem with this is that, let's say, if one of those ACE construction companies own the trademark and they were first to use it and they own the trademark, they could ask the other ACE companies to stop using their brand. Okay. So this is so we come to the first case study, and this is dear to my heart only because it just illustrates everything why a company needs, or a small business or even any company needs a trademark. So this case was a couple of years ago. So the lesson here is, you need to check your brand is trademarkable at the start of establishing a brand, because without knowing if your brand is trademarkable or not, you could end up being in this situation. So this case study was Musashi versus Asahi, Nestle versus James Christian. And so Nestle took James Christian, who was a sole trader, to court. And James must have been very confident or naive. So instead of changing his name when Nestle asked him to change it, he said, "I'm happy to go to court." So they went to court. So unfortunately, James lost. So these are the lessons from the from the court case. Okay. So James said, I didn't know that I was infringing on Musashi's trademark. My brand name is Asahi. It's very different to Musashi." And basically, the judge said, "You can't claim ignorance as an excuse." So that went out the window. He said, "I have a domain name. I have a trading name." Uh, and the judge said, "The domain name or the trading name does not offer you any legal protection," even though he's been trading for, I think by that time, 3 or 4 years. Okay. So what happened was that so without having a trademark registration, what you in fact are doing is you're leaving it to one judge. So when you go to court, you're leaving it to one judge to decide if your brand is different or too similar to another brand. So in this case, the judge had to decide whether he thought Musashi and Asahi were similar. So you're leaving it to one person. Okay. And in this case, the judge agreed with Nestle and thought that the two brands were too similar. So therefore, he thought that it would cause confusion in the marketplace. So in his judgment, he said that James should have attempted to obtain a trademark at the start of his business when he first established it, because if he somehow was successful in obtaining the Asahi trademark for vitamins and supplements, then Nestle years later could not have taken him to court because he would have had a registered trademark. Okay. However, because James didn't apply for it, he didn't actually know he was infringing or not. And it could have even been that if James had applied for it at the beginning, the trademark office would have said it was too similar. And if that was the case, that would have indicated to James that he needed to change his trademark name or his brand name at that start, because the trademark office thought that there was a chance of infringement. Um, and that could have been another avenue where he could have had a chance to change his brand name at the start because there was an infringement. Okay.
Does that mean that James had to change everything, the whole brand, the URL, everything?
Well, I'll tell you what happened to James. So essentially, he lost the court case, James, and his online business had to shut down. Only because by the time, so he had lost his initial investment. He said he spent 200,000 just to establish the packaging, the brand, and everything. Because he took it to court and appealed and everything, he ended up having to pay for Nestle's some of Nestle's legal fee. And because it was over 3 years, he was pretty stressed and was uncertain about the business for over 3 years. So essentially, he shut down because by the time he had to pay all the legal fees, he had no more money to rebrand. Okay, but to answer your question, Tonia,
Would they have
he would.
sued? Oh, sorry.
Oh, he would have had to rebrand everything. Yeah. Oh,
Would they have sued him if he just stopped using the name? Like, did they initially just
yes.
say, yeah, okay.
So that's why I said at the very beginning, he was very brave that when Nestle sent him a cease and desist letter, he didn't want to. He said, my business is about $500,000. I don't want to change. You guys are just bullies. But what he didn't understand was the trademark law is not common sense. Like you and I might say, I don't think Musashi and Asashi are similar. Like we might not think that. But James Christian definitely didn't think that there was any breach. And he uh, went to court with Nestle. But at the time when he received it, he would have been said, maybe told, if you change it, we won't pursue you. But he didn't. He actually took Nestle on. Okay. So because he took Nestle on and he didn't really understand that ultimately there was a chance he was definitely going to lose because well there's various factors here. Nestle has got deep pockets. So even if they lost the infringement, potentially they would have gone after him under a different law, which is passing off. So I think James was very, very brave to have taken Nestle on in the first place. But I guess the lesson here really from the judge is that James should have just checked at the beginning whether there was any infringement, and that if he actually owned that trademark at the start, Nestle wouldn't have been able to come after him. So at the beginning, you can find out whether your brand would be infringing or not, and then at that time, you can choose to run the risk of infringement or change your brand at the start. So that's really what the judge was saying to James. Okay. And let me just show you. I think there.
Just a minute, Ben. You turned yourself off mute.
We
Oh,
lost
sorry.
your audio.
There we go.
He did use the same colors, didn't he? He didn't do himself any favors.
You think he was being a bit cheeky anyway?
Yeah, maybe he was being cheeky, but I mean, Musashi Asashi, okay, the word, but then the logo, when you look at it, well, maybe he was trying to piggyback on Nestle's brand. So essentially, like this, I said, this court case really says if you're looking to do a brand, it's going to be successful, then you really need to trademark or make sure that your brand is trademarkable from the start. And it becomes more complicated when you're trying to also launch a global brand. You really do have to do a lot of research because trademark ownership is per country. Not there's no such thing as a global trademark. Okay. So that's case study 1. So case study 2 is use it or lose it. And I use this case study because they're a big company and they've lost their trademark a couple of years ago. Okay. So unlike a domain name, you can't, like, domain names can be, you can cyber sit on those domain names, but a trademark you can't. You either use it or you lose it, because someone can challenge your trademark if you haven't used it over a period of 3 years continuously. Okay. So this case was, I'd say about 2 years ago, I think. And Supermac, who is a Irish hamburger joint, they wanted to expand to Europe, but they couldn't because of the threat of McDonald's suing them because McDonald's owned the trademark Big Mac. And but then Supermac goes, we're gonna revoke their Big Mac trademark. So they took McDonald's on. So basically McDonald's, it's 2019. So McDonald's lost the Big Mac trademark in Europe. And Supermac basically were successful in revoking not all their Big Mac trademarks, but the trademark for restaurants. So trademarks, there are 42 classes of trademark protection, and the big companies tend to overdo their trademark protection claims. So McDonald's had a trademark for Big Mac for the burgers, for restaurants, and for a few other things, okay? So, but Supermac actually revoked their restaurant trademark for Big Mac. And people go, how can they do that? We all know about Big Mac. Well, I ask you the question, has anyone seen a Big Mac restaurant anywhere around the world? And the answer is no. We see McDonald's restaurants, but we don't see Big Mac restaurants around the world. So in this case, the Big Mac trademark was not being used as a restaurant. Okay, so therefore it was easily revoked by Supermac, because what they wanted was a trademark for restaurants. They wanted a Supermac trademark for restaurants, and Big Mac's restaurant trademark was in the way. And so instead of wanting to be just starting up the franchise over in Europe, they wanted to make sure that they did it right and that they actually own the trademark, so that when they invest all that money to expand to Europe, I mean, to get a burger joint restaurant up is a lot of investment for those companies. So you don't really want to be really nearly expanding without knowing that you're going to be safe. And you also don't want to be locked in the courts with Big Mac just, trying to sue you. So they then took the front foot and said, we're going to revoke their trademark. And they were actually successful. The other thing that was interesting as well is that they went after their Big Mac their Big Mac burger trademark as well. And I just wanted to show you an example of why they may be successful, because their trademark is Big Mac, okay, for Europe. So, but then when I looked around in, I think, France, they've had Mon Big Mac. So it's not Big Mac in France, it's Mon Big Mac. And then Le Big Mac and Le Grand Le Big Mac. So as you can see, as I said previously, with the trademarks, you've got to use it how you've applied for it. And if you haven't applied for Mon Big Mac, but you applied for Big Mac, it's actually different. So Supermac is also trying to revoke the Big Mac trademark in Europe as well. And interestingly, when McDonald's lost Big Mac trademark for restaurants, I think they couldn't stop Supermac from opening up in Europe, but they actually did do a press release to warn any small business owners who were wanting to take advantage of this fact, that they would then pursue people that were opening up potentially Big Mac restaurants, that they would pursue them under a different law. So that's how important it was for them when they lost their trademark, that they wanted to make sure that nobody else was going to start using or something similar for Big Mac. So if someone like McDonald's can lose a trademark, and it's because the trademark laws state that you have to use it or lose it, basically. So if a registered trademark owner does not actively use the trademark as registered, the trademark can be revoked. And trademarks are not like domain names, and you can't stockpile them to reserve it for yourself. So the case study 3 is basically a trademark trumps a company name. And this is a very real example. A client came to us and their accountant told them that they can use the brand name iHub because they were able to get iHub Optical Proprietary Limited. So they opened, I think, 2 or 3 optometry shops. They had glasses made as iHub. They had vans or car wrapped with iHub. So they spent a bit of money with signage and everything. And within about 2 months of them opening, they had received a cease and desist letter from OPSM. And they actually rang us when they received the cease and desist letter. And before they could even tell me who sued them. I said to them, don't tell me who sued them. Let me look it up. It took me 5 minutes. And I said to them, is OPSM suing you? They said, yes. And I said, that would have been a very quick check for your accountant. But the thing is, the accountants are not trademark experts. It's not their job to check the trademark registry. So often, many times, I try to work with accountants because I could easily tell them within 5 minutes of this client. So if that accountant had rung me, I would have easily have said to him, tell your client to change their name, because even though they can get the company name, but if they use that name in the marketplace, OPSM will see it and they could potentially be asked to change it. So anyway, the fact was that they rang us because OPSM has sent them a cease and desist letter. And we basically said, well, you can continue using it, but OPSM will take you to court and it's up to you. You can go to court and a court case could cost you 50,000 to 100,000, or you just bite the bullet now and rebrand. And they sensibly rebranded. And the other thing, just as I guess a suggestion, is that if you ever are starting up a new business or a new product brand, Google is actually a very good search engine for you to check it out. Because I did 2 checks when they rang me. I checked Google and I also checked the trademark registry. And when I checked trademark Google, look at that, it was already there. OPSM iHub. So OPSM was already using it, and as I said, the accountant and the lady didn't actually understand that they were infringing, even though they got the company name. And as I indicated to you before, the company name does not have to equate to the brand name. So OPSM can own a sub-brand called iHub. So anyway, the client had rebranded, ended up costing them about 26,000. And interestingly, this is the point that I want to make. They are still trading as iHub Optical Proprietary Limited because OPSM cannot make them change their company name. But they're trading as Expectico. So just wanted to show you. That's how their new brand is. And anyway, when I went to see them when they rebranded, I got some eyeglasses from them as well. And so that's a really point in case where you may essentially the trademark owner. It's the owners of the trademark owner to send a cease and desist letter to someone. So there's no trademark police out there monitoring infringement. It's the owners of the trademark registrant, and the bigger the company, surely they will probably send you a cease and desist letter, more likely. This case study is about just to show you how powerful a trademark is. So in Australia, there's actually a Nike trademark that is not owned by Nike Sport. It's actually owned by a company called Nike Innovate CV since 1975. And this shows you that if you're a smaller company and you own the trademark, it doesn't matter if a bigger company is established later, they can't make you change your name because you own the trademark, okay? So that is why when I say to small business owners, it's not really about you suing someone else. It's more that you are protecting yourself so that if someone bigger comes along, they can't make you change your name because you own the trademark, okay? So this is the Nike that is not Nike Sport. They actually were first to file for the trademark and first to own it, okay? And basically when Nike Sport wanted to enter into this space, they couldn't make fragrances in that. They actually had to do a deal with the owner of the trademark in Australia that owns Nike in Australia. And that just shows you the power of owning a trademark, that even if a big company comes along, if you're the owner of the trademark, you could license it out to them, you can stop them from using it. You can sell it to them. So that's why it's important that you own the trademark. Because let's say, for example, if this fragrance company didn't own the trademark, and Nike being such a big company, they could have come along and bullied them at the end of the day, bullied this company to say, we're going to take you to court for passing off. And ultimately, again, it'll be down to how much money they've got to go through the courts to do that. But because this company actually owned the trademark, Nike couldn't stop them from using it. And a most recent court case, I don't know if you guys heard in the media, Katy Perry versus Katy Perry. It's been doing the rounds on the media. And in that case, the small business, the fashion designer, the smaller party, owned the trademark first. And it was actually the singer Katy Perry that wrote her a cease and desist letter telling her to stop using her brand name. And the smaller Katy Perry said, I actually own the trademark. So you can't actually tell me not to use my brand name. I own the trademark. Okay. And this woman had principles, and she must have deep pockets because she actually was very brave. She took the big Katy Perry to court because I think the big Katy Perry was licensing her Katy Perry brand name to apparel companies. And I can't recall which company she licensed it out to, but it could have been even Peter Alexander, but I'm not quite sure. But basically, because she was licensing it and she was infringing on the smaller Katy Perry's trademark, the smaller Katy Perry, or the fashion designer, took her to court. And I think it was only last week that the big Katy Perry has been told she can't use that brand in Australia without negotiating something with the smaller Katy Perry. And the thing is, we may never know what the deal is because a lot of these big companies, the big companies do not want the judge to hand down damages. So what tends to happen is that they'll settle before a damages claim is imposed on them by the judge. So it'd be interesting to see whether it goes all the way to a final judgment for damages. But I'm assuming that the Katy Perry, the singer, will probably negotiate with a smaller Katy Perry on some sort of an arrangement so that maybe they'll coexist in Australia in somehow. But that example just shows you that because the smaller Katy Perry owned the trademark, she couldn't be bullied to rebrand. Okay. First to file is important. So China and Japan are first to file countries without having to use it. Where in Australia, if you're first to file, but someone has used the brand previously, you're still, how can I put it this way? So, for example, if you file for a trademark, but you were not first to use it, let me, but I just want to think. In Australia, if you're using the brand name first before someone files for the trademark, you can continue using that trademark. So yeah, so if you were a brand and let's say we're Apple, we use Apple as an example, and Apple started using the brand Apple first, and then someone trademarked Apple after them, the person that obtained the trademark cannot ask Apple, the first user, to stop using it. They can only tell any Apple users after that to stop using it. Where in Japan and China, they don't really care about whether you've got any use or not first. You can go to China and trademark anything without using it first. Okay. So the example here is that in 2012, Apple actually had to pay a Chinese company who trademarked the word app, the iPad trademark in China. They paid them 60 million USD for the iPad name in China because in China, they were not first to file for the trademark. Okay, where in Australia, let's say if the same case happened, Apple could potentially revoke that person's trademark or say that they did it in bad faith. But in China and Japan, there's no bad faith, and there's no you can't revoke it just because someone has been first to file your trademark. Where, like I said, in other countries like Australia and New Zealand and other countries, that if someone's like try to get your brand in bad faith, you've got avenues to revoke their mark. Okay. The same thing with Pfizer. They were not the first to get the word Viagra in China, and they still can't buy it off the people that own that name because they don't want to sell it. I think they're making more money selling that brand under the Chinese formula than actually selling it back to Pfizer, that name. And Penfolds and Michael Jordan are in the same situation. Michael Jordan's desperate to get Michael Jordan back, but again, they can't get it because someone in China had trademarked Michael Jordan in China first. And they're probably, again, like I said, making more money out of it than that. Where, let's say in Australia, if you actually had trademark Penfolds and they had a reputation, there are avenues for Penfolds to basically revoke the smaller person, the person that's applied for it, under various, avenues of bad faith filing, or they weren't first to use it, or they were passing off. Case 6 is, again, a demonstration of how a bigger company cannot stop you from using a trademark if you're the trademark owner. Okay, so in New Zealand, our client was Indian Accent, and there's an Indian Accent in India, and they basically received a cease and desist letter from the Indian company, and we quickly checked if they actually owned a trademark for Indian Accent in New Zealand, and they didn't. So then we quickly applied for the trademark. It takes 8 months to get a trademark, okay? So we quickly applied for the trademark for them, and we basically told them to delay responding to the Indian lawyers until we get the trademark in New Zealand. And so our client was successful in obtaining the trademark in New Zealand, and the client's now protected, and they're legally able to use that name and stop Indian Accent from coming. And the good news is that our client actually doesn't care if Indian Accent comes to New Zealand from India. They're more than happy to license out Indian Accent to them now. Okay, so this example just shows you from being on the back foot where they've received a cease and desist letter. And we were very lucky that their Indian lawyers had no idea about, I don't know, I mean, they should know that trademarks are per country. Just because you own a trademark in India doesn't mean that it applies to New Zealand. So we were able to successfully obtain that trademark for the client. And like I said, the client was more than happy to negotiate with Indian Accent in India for them to come to New Zealand, and they'll just charge them a fee to use their brand name. So only a trademark protects your brand within the country that you've registered to trademark for. I might just skip this very quickly because this is more about a certification mark, and it's probably not as common for people to get certification marks. So unless you've actually got clients that may have.
How about we do this? Is anybody interested in learning about certification marks? Raise your hand. If not, we'll move along. I think you're okay.
Okay, I can move along.
Yeah, there you
go. Okay, so hold on. Okay, so I can move on. Okay, so I'll skip certification marks then, because certification marks is really more for industry associations. So I'll skip that. Okay, we'll go down to case study 8 then. Okay, so Instagram. So we had a client, basically she was in clothing on Instagram, and another company was in actually body deodorant, I believe, or selling body deodorant. and they received well, actually, they didn't receive anything. What happened was that she was happy going along selling children's clothing, and next minute, her Instagram account was shut down. So she had to ring Instagram and say, "Hey, what's going on? Where's my Instagram account?" And essentially, by ringing Instagram, Instagram said, "Oh, we had an infringement complaint about you, that you are infringing on somebody else's trademark. And so we just removed you." Okay. And I've actually taken a screenshot from Instagram's intellectual property terms and conditions. And it does say, if you believe the content shouldn't, basically they're saying that they don't want to be in the middle of the intellectual property, but if you being the owner of the trademark thinks that someone is infringing on your mark, you can actually ask Instagram to take down someone's Instagram account. Okay, so that's what's happened to our client, that someone complained about her infringement. And in this case, she had 25,000 followers already accumulated on Instagram. So she was in she was in a mess. She was like, "I do not want to lose my 25,000 followers." Okay. And so what had happened in this case was that we contacted the other party that took her down, and we had agreed to rebrand. Okay. And so we then got the trademark for our client, just to show them that it was in good faith that we were actually rebranding. And then we negotiated that that if we rebranded, that company that took them down would write to Instagram and say that, can they reinstate that Instagram handle? And within, like, let's say 48 hours, our client had to quickly change her Instagram handle so that she could keep her 25,000 followers. So I'm just wanting to make that point, that you can be shut down and reinstated, but that requires negotiation with the other party that took you down. Okay. And so there was a happy ending to this story, because the client was able to get her Instagram handle back with her 25,000 followers, but she rebranded and had a new Instagram handle. And that was good for her, because basically she just said, "I had trademark issues, we've rebranded," but that went out to all of her 25,000 followers. So that was a great result. So that's why it's important when you start your business, that you have a unique brand in the first place, so that you don't come across potential infringement. And basically, when you're starting a new brand, you need to be first to use the brand as well. Okay. And be first to promote and sell the products. Anyone wants to know about NFTs or not? Because I can skip this as well. It's this. So I'll quickly just talk about NFTs. So with NFTs, let's say, I'll give you an example with Nike. They've got a trademark for shoes, okay, and potentially for shops, but they're all physical shops and physical shoes. So when this metaverse came up, where NFTs are created in the metaverse, and in the metaverse, the shoes were being sold. Nike shoes, like as in digital Nike shoes were being sold in the metaverse world. And basically, I think the companies that were being infringed were trying to sue the people, but what they found was that they didn't actually have an NFT trademark for Nike. So I guess what I'm just trying to highlight to you is that in the metaverse world, there's actually now a trademark class for NFTs, so that if you're running an agency, they've got clients that are working in the metaverse and they want to get a trademark, it's really important to know that just because they've got a trademark in the real world, they actually have to get a trademark in the metaverse world as well. Okay. And, you know, Hermes, Saks, Ticketmaster, they're all getting NFT trademarks at the moment because they're all entering the NFT, the metaverse world. Just quickly, just talking about domain names. So a domain name doesn't actually give you protection for your trademark. And these are various trademarks, domain names that you can get. And basically a domain name is fantastic because it's your real estate on the internet. However, it's really important that to know that domain names does not provide you any intellectual property protection at all. Other intellectual property that you may have heard of, which is copyright. Okay, so in Australia, copyright is automatic, but you need to put the symbol C on all of your brochures, on your website, just to claim that you want automatic, you are claiming copyright on those. So copyright is a term used to describe the rights that the creators have over literary and artistic works. So it could be books, music, paintings, sculpture, films, graphics design. And it's really important as well that when you engage a graphics designer, that you ask them to assign you the copyright. So a lot of people get caught out, and I've actually had some clients get caught out because when you're small and you're starting a new brand, you don't think your brand's worth anything. But when you get bigger, your brand becomes something. But if you at the beginning, let's say, engage a graphics designer and agency to do the logo for you, and you have not asked them to assign you the copyright as part of engaging them, even though you've paid the money, you don't actually own the copyright to that logo. So later on, when you become big, they could ask you to pay them a royalty for the copyright of that logo. And that's actually has happened where we've had a client that was in the cosmetics industry. She was very small, then became very big. And when we went and asked for the copyright from her agency, they asked for more money, even though they had actually paid a lot of money at the beginning when the logo was created. They asked for more money to assign the copyright to them. Okay. Okay. Let me just see. Patent is the right, the protection of rights over an invention, basically. So if you've got a device, a method or process, it's very actually hard to patent method. So really I tend to say to people, you can't really, it's really more a physical product like an engine or something, okay, that you can exploit that, the patent. So it's the protection of an invention, the patent. Okay, we're down to the last two slides. These are my top 8 tips to create a trademarkable brand. Okay, so first of all, you need to avoid descriptive names or words for your brand. SEO people will tell you that it's really great to have that. However, you cannot trademark anything that are descriptive in your brand name. So if you were Sydney Town Planner, you won't be able to trademark that because it tells you what you do for a living and where you're located. However, if you were, let's say, seriously trademark planning, you could trademark that because seriously is the uniqueness of that brand, not the town planning part. Okay. Avoid using somebody else's brand, and that is really important. If you find someone has already got that name on Google, like when you do a Google search or a trademark search, avoid it. It's not worth it. Okay. It's just not worth it. There's so many words out there that you can find. Don't copy somebody else's name. Avoid personal names or surnames because it's really difficult to trademark those as well. It's not impossible to trademark a first name or surname, but it's best to avoid it if possible because it's hard to trademark that. Avoid geographical locations as well, because you can't trademark, Melbourne or Sydney. So it's probably best, as I said in the Sydney town planning thing, that to avoid that. Also, just as a cheap option to make sure that you can avoid someone trying to take your name or anything, is to obtain as many domain names as you can, just to basically get the domain names that you want, so that you can save the real estate on the web, on the internet. Another thing is to invest in a good graphics designer, because I also see a lot of my clients will get a trademark, but then they'll use someone from Fiverr, or I'm not quite sure, all those Airtasker people, where all they're doing is probably copying somebody else on the internet and whipping up some cheap logo. Don't do that, because you don't even know where they got that logo, that image from. That it's actually best to probably invest in a good graphics designer that will create something individual for you. If possible, trademark, 8 to 12 months in advance, because that will save you from a lot of heartache, if there is, because even though you apply for a trademark, you're not guaranteed to get it. So I've had something happen to me, and I'm a trademark attorney, and I'm so glad that I took my own advice and I tried to trademark a name for my pet supplement business on the side, and I actually ran into trouble with that name, and I was so glad that I actually took my own advice and then applied for the trademark first, and then now I've actually found a new name that is very unique, and hopefully it'll go through this time round. And also, once you've obtained the trademark registration, you need to police it. So if you don't police it, you may lose distinctiveness of your mark. So, for example, with Seriously Trademarks, if I found that somebody else was using it in, I don't know, Adelaide, I should write them a cease and desist letter, just to show them that they're infringing on my mark. And if they don't change it, I still have an avenue in the future to sue them if I want to. But ultimately, someone like me, because I'm not a large firm or big legal law firm, potentially wouldn't really sue that person. What I would try to do is basically send them a cease and desist letter and just say, listen, you're infringing on my mark. I would appreciate if you would change it, and just be on them to change it, instead of threatening them to go to court, because it's just too expensive, and ultimately, I'm protecting Seriously Trademarks more for my continuous use, as I said previously, than really looking out there to stop somebody. And I've actually chosen a name that's a bit silly in the legal world, and I don't think anyone in the legal profession would want to call themselves Seriously Trademarks anyway. So at the very beginning of my practice, I chose a name that I knew no other legal firm would want to use it, because it is a little bit different. I mean, most law firms use their surnames, or they use descriptive brands and things like that. So, and that's pretty much it. So I'm hoping that, I know I went through a lot of things, that at least you would have gotten some information that was useful, that applies to your company or for your clients. So feel free to look me up on LinkedIn, email me, or call me if you wish. So it's been my pleasure to do this webinar for Jules. So
Oh,
thank you.
well done, Binh. There was so much information in there. And even I have a list of questions that just is a mile long. But there were a couple of questions in the chat.
Yes, so I can answer them now. Sorry, I just wasn't watching the chat as I was speaking.
No, we'll do them
Yeah.
at the end. So from Karen Hall, who had to leave, unfortunately, how, where do you check overseas for trademark names, specifically New Zealand, USA, and UK?
Okay, there is a a WIPO trade. So I could potentially, if I can find it, hold on a second. So,
You're looking for it online?
yeah, I'm just trying to see if I can find it on. So it's I go to the WIPO database. So WIPO, WIPO.
Okay.
And the
And
WIPO
that shows you?
database, no, well, you need to know how to use it. It can be quite confusing even for someone like me, because I tend to use the Australian one more. And so let me just see if I can find it, and then I will put it in. So I'll stop sharing so I can go to the website. Just bear with me. I'm just going to the.
Well,
Okay,
if
so
it,
I'll put it in here. So I mean, there's no secret to this. So there you go. So maybe Antonia, you may want to send that to Karen who left. So that's, yeah. So if people go to that website, you can
it's in the
actually
chat.
search for, yeah, it's in the chat. Okay.
Great, fantastic. One of the other ones, which is from Pawandi, who
Yeah.
works with Jules at She's the Boss. Do we need to
Yeah.
change our trademark or update it, I guess, our copyright sign every year, 22, 23? Does it have to be continuously updated?
It I see there's variations of it. I think it tends to be the year that it's published. So so that I think if you looked at my presentation at the bottom, I put copyright 2023, but and I think to be sure you could probably put the dates you want. So I often see this, let's say on Coca-Cola or various other ones, where let's say the first time it was used, 2005. So they'll say 2005 dash 2023. So I think that's probably the best way of doing it if you've been around for a while. Okay.
Okay. Nikki Cully. Okay, Nikki, you might want to throw yourself on for this one because it's going to need some explanation.
No, we applied for a trademark many moons ago, and we did our research. We did everything we were supposed to do, and we did that pre-registration with IP. We did all of that. They said, "Yep, all good," and then it was registered. And then a couple of months after that, we got a letter saying, "Hang on a minute, no, we're going to have to revoke that from you."
IP Australia?
Yes, IP Australia. And so we got in touch with a lawyer, and we've got until July this year to sort of go back and say, hang on a minute. But their basic thing was, when we spoke to the lawyer, they said, oh, IP for one shouldn't have accepted for the pre-registration because we paid for it. And two, they're telling you, no, you can't use it because it's based on someone else who has the URL. So that was really interesting. And it's like, well, what happens in those cases for someone who like?
So did you actually get a registered trademark? Like did you get a certificate to say it was registered?
We received the letter, and I think it was acceptance. We got the acceptance letter.
No, so that's not registered.
No.
So,
yeah.
so
I don't
basically,
think it's through the full process. Yeah.
No, 8 months. Did it go through 8 months?
I don't know. Actually, I can't remember. It was so long ago, but it was.
Oh, do you know the name? Because I can look it up.
What do you mean the name of the actual
trademark? Yeah.
Yeah, I can give it to you outside of this.
Oh yeah, well, maybe we can talk.
Mm.
Okay, just to answer your question, so until you actually get a registered trademark certificate, you haven't gone through the process.
Yeah, it's still in process.
Okay, so you have, so they've got what they call preliminary examination, and then you get a pre-approval, and that pre-approval can be revoked later on down the track, as long as it's within those 8 months. So unless they've actually given you the trademark, things can happen in that 8 months.
Yeah.
Okay. So by the sounds of it, you didn't actually have a registered trademark.
No,
They just changed their mind.
Yeah.
And that is possible. The reason that is possible, and even when you get a registered trademark, IP Australia actually has up to 6 months after the registered trademark to have some avenues of potentially revoking it. Okay. So Yes, so there are laws within the legislation that allows that to happen. And ultimately it's case by case. Okay.
So,
So
Binh, are you
yeah.
saying that a trademark registration takes over 8 months
Yes, it's
to?
8 months. Yeah, in
Okay.
Australia it's about 8 months if there's no problem. It can take up to 12 months to 3 years overseas, depending on the country. And like I said, unless you've actually got the registered trademark certificate in your hand,
You got nothing.
you don't have it. Just because you get pre-approval. I mean, I guess it's like when you go to the bank, get a bank loan, a pre-approval.
Unless you got the money in the bank.
Until
Yeah.
it's actually like
Don't buy
the
anything.
money's in your bank, it's not
Yeah.
done.
So
Go
how long
shopping
does
spree.
a trademark last?
10 years. So once you receive the trademark, it's 10 years.
Okay. And is it expensive?
Not really. I mean, you can do it yourself as Nikki has done. Or you can go to a trademark attorney like myself or other companies. One thing that you've got to be very careful is, especially the law firms, they won't quote the full fixed fee. So they'll quote you the application, but then as they go through the process, they'll send you an invoice for sending you an email, because that's not the application fee. So if you actually go to a like a full-fledged law firm, just make sure you ask what is the fixed fee for the whole process, not just the application, because the terminology are a little bit different. So with my particular practice, I'm fixed fee, so it's $2,000 plus GST, including the government fees and including my time. And it doesn't matter whether I spend 5 hours on it or 2 weeks on it with you, it's a fixed fee. But because the reason it's fixed fee, because I actually manage it for 8 months for the client. So I won't be actually charging them to send them an email to say, it's gone to this stage, here is the certificate, where a lot of the other firms will not quote that up front, will quote it as additional services. And they'll say trademark application is this fee. And people will say, isn't that part of the application? No, it's not. It's their personal fees by emailing you and stuff. So that's why I
Fantastic.
would say that if you do engage external companies, ask what is the total cost, and also ask, will you charge me for an email? Will you charge me for if something comes back negative that you talk to me, that will you charge me for that as well? So it's really
Gosh,
important that
it's a
you do
lot.
that. So yeah.
Now, Liana, is that correct? Am I saying that right, Liana? Oh, great. Did you want to ask your question? Because it sounds like it's convoluted as well.
Oh, you just made the point before that you know, a URL is a different thing. It's like a separate thing. So I was wondering, like, what if you own a URL and then later on you find out, or someone gives you a cease and desist, whatever, because they've trademarked the business name. Do you still own the URL I'm not saying the trademarked name, but the URL itself?
Yeah, okay. That's a really great question, Liana. So no one can take the URL off you, okay? Because it's not trademark. It's not the URL. The only time that they could potentially revoke your rights to that URL is if you are infringing on their mark. Okay, so I'll give you an example. Let's say seriouslytrademarks.com.au. Let's say that. If I own that trade, let's say even if someone, so let's pretend that I didn't have this business, but someone owned the trademark for Seriously Trademarks, and I cyber sat on that domain name. I can still keep that domain name, seriouslytrademarks.com.au, but I can't promote a trademark business on that URL.
Can you sell, but you could sell them the URL, yeah?
Yeah, you can sell them the URL, but before you sell it to them, depending on the company, they would rather revoke your your rights to that domain name.
So
because
they do that?
There's a tribunal in in Europe. So there are avenues that can revoke it. So if you don't have intentions to open a trademark business for it, they can't take it off you.
Mm.
So at the end of the day, it's more about negotiation. Okay. You have the right to that domain name, and the only time they can take it off you is if you start up a business that's a trademark business, because they own a trademark, seriously trademarks as a registered trademark. That trademark owner cannot take that URL off you. They should really try to buy it off you. But if you ask for too big of a price, they may go, nah, I'd rather go and revoke your mark. Like, I'll cause you trouble. So ultimately, the law is there, but ultimately it's the gray parts that you've got to negotiate. Okay. So with URLs, unless you're planning to use it to infringe their mark, but if you're going to open a restaurant called Seriously Trademarks, well, you can argue, well, I'm not going to use Seriously Trademarks for trademark consultancy firm. I'm using it to open a restaurant or whatever. You know what I mean?
Well,
I guess I'm wondering more, you know, in the case of, let's say somebody has been trading and not, you know, they using ignorance as an excuse. They never knew that somebody else had trademarked their business name. Okay, so let's make something up like, you know, I don't know, Fantastic Jeans. So they're trading as Fantastic Jeans. They don't realize that someone else owns the trademark for Fantastic Jeans. They've been able to buy the URL for whatever reason for fantasticjeans.com.au. They're later sent a cease and desist by whoever actually owns Fantastic Jeans trademark. In that case, you know, they're fine. They're like, okay, no worries. We'll change our trading name. Can they still at least sell the URL?
Yeah, you could. You could sell but at the end of the day, the other party has to be willing to buy it.
Yeah,
but you're saying, but can you do online sales using the Fantastic Jeans URL for yourself selling the thing that they're registered for?
So let's say the company's at least getting something out of the fact that they've got to now rebrand.
So you're talking about selling the URL or using the URL?
Correct. No, just selling them. Going, okay, fine, you can have it, but you got to.
You can do that at any time.
You have every right to sell it to them. You have every right to. But
so
my
they don't
point
automatically get it. Is the main point?
No, they don't automatically get it unless they want to take you to the tribunal.
Yeah.
Okay. So you with URL, you don't automatically get it. They've got to cause a bit of issue. So it's really by negotiation.
Okay.
I've had many people ask me to buy URLs that I've had listed for their companies, which I've just sell outright. You just negotiate a price and just sell it to them.
Yeah, you just negotiate a price.
Transfer it. Yeah. Easy peasy.
But now, if it's a big company, they may not want to pay for it. Or I don't know. So like I said, with URLs, there's no protection. You own the URL. And basically by selling it, you may have to get a domain broker that knows the rules more than I am. I'm not a domain broker
transfer
expert.
it.
Yeah.
It's easy peasy.
I don't know what the rules are. All I know is that we've been involved in a few URL cases, and a lot of the times people go to this tribunal in the Europe, which is supposed to convey everyone's domain issues from around the world. And to tell you the truth, it's a lot of money, and you don't really know if you're going to win or not. So in some ways, it's probably best to try to negotiate a good price or reasonable price so that your client will get something out of it.
Yeah, to get some money. Now, Julia has a question.
Yep.
Did you want to ask it, Julia, rather than me? And there you
myself. Yep. I was just wondering, so what happens when your trademark's about to expire? Is the Trademarks Office proactive about reminding you, or do they let it slide? Or do I need to diarize? Or
this is where I fell down in the crack. Victim number one here.
Okay, I answered this question to Antonia the other day. Basically, IP Australia or whichever government body it is around the world, they will let you know, but they don't email it to you. They put it in your email, in your login.
Inside the portal, which you never look at again.
Do they send notifications?
No. They used to. They used to send paper. Now they don't. They expect you to be in your portal.
So you have to diarize it. Yes, Julia.
Okay.
And now, which is the next evolution of that question, what do you do once your trademark has expired because you're not inside the portal hanging about?
Oh, you can still use that portal, because once you open a portal, that's your portal into IP Australia.
No. What happens to your trademark? Is it zip gone? Thanks for coming.
You have to you've got to reapply. Yeah. You've got to reapply. And I said the bad news for Antonia is that if someone else has got something similar before hers or whatever, there's no guarantee that Antonia is going to get her trademark back.
Yeah.
So.
Oh, and here's a question for you, just for the logistics part of it. There's copyright, there's patents, and there's trademark symbols. When you get, you obviously put your copyright against your creative logo, but do you supersede that when you get your trademark TM? In your logo, do you put TM instead of the copyright symbol?
Oh, no. So copyright is just for all your marketing stuff. Collateral is at the bottom. The trademark. So when you get a trademark, it depends if it's a logo or a word mark. Let me share my screen again so I can show you. Okay, it's easy for me to do that.
I know how to use it. I just don't know which one is superseded by which, and because I'm imagining if you have a trademark, then that sort of tells everything. And you put
you put an R if it's registered as a trademark. You don't put copyright on a trademark.
No, but I'm guessing that if you put an R for a registered trademark, then people would be aware not to try and infringe on your company name.
Yeah. And TM does not provide you any protection. TM just tells people that you're using that brand as that you want to use it as a brand. So TM, I think a lot of people use it just to scare people off without actually getting a real trademark, and that's possible as well. But it's the R that is what gives you the legal rights to it. Yeah.
Fantastic. And you wanted me to ask this question, which is a really good one. Yeah. When is a trademark useful? Because it is a process.
Okay. So I often tell people, if someone came to you to ask you to change your brand name and you are happy to change it straight away, then you don't need a trademark because you're not valuing the brand you've just created. Okay. So for example, if I didn't care if someone came to me and said, you need to change Seriously Trademarks tomorrow, and I go, okay, no probs, I'll change my brand, then I don't need a trademark. But because I value what I've built, the reputation behind Seriously Trademarks, I don't actually want to be told I have to change Seriously Trademarks 10 years later. Okay. So for me, if you value your brand and the reputation you're going to build behind that brand, then you need a trademark. But if you don't care if someone asks you to change it tomorrow, then you really don't need a trademark because you're not really, to you, it's just a name that you're using. Okay.
What happens if you go global? Do you have to research it before you do it?
Yeah, I've actually had clients where they've had a game in Australia that was, I think, trademarked here, but then we couldn't trademark in the US, so then we changed the name in the US. And then when they were ready to go to the UK, both those names were not available. So then so basically that client has got 3 brands for the same product.
A lot of management, but very important so that they know they have that continuity of business. Yeah.
And they were very lucky that they checked with us because they potentially would have been sued by Lego in the US and another big company in the UK. Like if they had gone to those countries without checking whether they were infringing. So then we actually ended up changing the names for them in those countries because you wouldn't really want to be exporting to the US and being sued by one of those big companies.
Gosh, no. Well, that was amazing, Binh. I know I have to talk to Binh later, obviously. And I believe someone else has already reached out to you on LinkedIn from the online learning table. Are there any final questions before we close up for the 1:30 finish? Oh, Liana.
Just in the case you mentioned before with, I think it was Indian accent or something like that. You said that, you know, basically you delayed their lawyers after they got the cease and desist and quickly applied for a trademark. And I just wondered how that fit in with it taking like 8 months.
Good
Yeah,
question.
so basically, I was very lucky that the Indian lawyers weren't doing their jobs properly. So basically, what they had done was given my clients heads up about them wanting to come to New Zealand from India, but they misunderstood that their Indian accent trademark in India gave them protection in the UK, sorry, in New Zealand. So, like I said, I quickly said to them, you need to get a trademark in New Zealand. That is the only protection you have because this other company is bigger than you. And I said, I don't know how you're going to do it, but you'll just have to delay them and hope that they're not going to check the trademark register in New Zealand. Because in the actually, I didn't mention this, with the trademark process, there's a 2-month period where people can object to your application. So if the Indians lawyers did their job and checked the trademark register in New Zealand, they would have seen that we were trying to sneakily, well, I wouldn't say sneakily, but we were trying to get the trademark in New Zealand. They could have actually objected to that, but they didn't. They didn't see that we were applying for the trademark. And so we had passed that objection period without any objections, and we owned the trademark by the time we then went back to them and said, hey guys, we're not going to be ceasing and deceasing. We actually own the trademark now. And by the way, if you guys want to come here, you'll need to negotiate with us to come here because we'll want you to be paying us some royalty. You know what I mean? So I mean, I don't know what happened in the end.
Any letters
because
you get,
I'm not
it's like
really
lost in the mail.
Yeah.
Yeah,
I mean,
so
ultimately,
you were able to stall them long enough, effectively,
Yeah, I was
like
able
for
to,
8 months or however long it took.
Yeah.
Yeah, okay.
Yeah.
So maybe a lesson in there is don't reply to a cease and desist until you've spoken to your
not really. I mean, okay, I'm going to be very clear in this webinar right now. A trademark attorney is not a lawyer, okay? We are, I don't know, we are able to dabble or advise on trademark law, I guess, in context to registration and filing and things like that. But we're not able to give legal advice outside of doing the trademarks. So that's why I said to you that what happened after I got the trademark, I don't know. All I could tell you is that I told the client that they can license it out to that company. And I told them they had to actually get trademark lawyers because I can't do commercial agreements that basically gives them the license. I basically am trying to prevent them from being sued or so I'm basically prevention. So what I do is prevention to get you the best trademark you can. But once it gets to sort of licensing or litigation or all those other things, I actually ring a friend. And I've got lots of trademark lawyers that I know. And it's probably best if you ever want a trademark lawyer, ring me because I know the ones that I use. I actually trust them. And so that's the thing. I will tell you what will happen, but ultimately I don't actually know what happens because I just send them off to lawyers.
Which is a great way to tie a bow on this because of this learning table, because once you get to that point, you might as well pull out your checkbook and you've got a long road ahead of you.
I guess the only other thing that I can say is that I actually have a marketing background before I became a trademark attorney. So I actually work really well when people are just starting out with their business, because if you come to me with a name and it's not trademarkable, I won't find you a new name, but I can actually guide you to find that name that you want that is more likely that you can use and file for the trademark and use it first. And it's because I've got a marketing background. I used to be a marketing manager and in my early career for the IT industry. So I actually understand marketing and branding, but I don't actually do the logos for you or find a name for you, but I just understand it to make sure that the name sounds good. I mean, I've had clients where they came to me with these names and I just go, oh my God, no, you cannot start your business with that name. That sounds so bad, because I've got my marketing hat on, and then I'll go, let's guide you to a better name that is trademarkable, and that's how my marketing and my trademark expertise really marries up very well. So.
And I think everybody can see how much of an asset you would be to their business and the advice for trademarking. Thank you so much, Binh.
Thank you very much to She's the
Seriously
Boss.
Trademarks.
So thank you very much.
And thank you everybody for turning up. And the recording will be on She's the Boss somewhere. Jules will let you know where it is if you want to see it again.
Okay. All right.
Thanks for coming, everyone.
Thank you. Okay, bye.
Thanks.